What if your worst-case scenario were to occur? A business continuity catastrophe, a mass shooting with a horrible consequence, an investigation that goes terribly wrong, a risk assessment botched, a physical security design with a significant gap that results in death, total supply chain failure in the midst of critical sales cycle, a botched background screening resulting in hiring a criminal that harms again. If your nightmare comes true, would you and your security team survive? Could you or your team be held accountable for the quality of your program? You're likely familiar with the concept of legal defensibility. We talk about it all the time. There are changes in case law occurring right now that all security practitioners should be aware of. The SEC recently conducted a briefing on this topic. We examined how security programs can be found negligent for not meeting professional security standards. I recommend you visit the link in this video description to read more about those changes. But legal defensibility is only one type of defensibility. I'd like to talk to you about 5 other types, all of which require us to meet a certain duty of care and all of which you are most likely to be held accountable to. What you need to consider is whether your programs and your team are defensible in the court of public opinion. Are they defensible to the victim and the family members? Do you have a system to maintain open, timely, honest communications with victims and their families? Do you have a long and short-term support option available? Do you make it a priority to communicate with compassion in crisis? Are they defensible to the media? Are you prepared to respond quickly and openly to inquiries? And are you prepared to manage, at the speed of the internet, the social media aspect of reporting and information sharing? Are you defensible to your employees? Have you maintained a culture in which employees trust and feel supported by your security-related staff and leadership? Do you have a system through which you communicate openly and compassionately to employees about events? Are they going to be defensible to the shareholders? Ultimately, these large-scale events will end up on the shareholders' agenda and most often taken there by the CEO. Are they defensible to you, yourself, and your team? Are you confident that if there were a loss of value or life on your watch, you would be able to say that you had done all you could to mitigate the risk? In any and all of these cases, you can clearly point to your internal program standards and how do they compare with industry standards that are now publicly available. However, publicly available industry standards are not always going to work in your favor. Some security industry standards are more like guidelines in language. The ASIS, ANSI, and SHRM Workplace Violence Prevention and Intervention Standard, for example, includes a lot of language like consider, discuss, or review when implementing an element. There's very little language stating that practitioners shall or must implement the recommendations contained in the standard. But because it is in a standard in name, courts, the media, and employees and victims may all use it as a sword against the company that hasn't implemented all of its recommendations. While this example specifically concerns workplace violence, any type of security program may fall victim to the same thing. That is why it's so important to ensure that all of your programs are robust and properly documented and, where possible, evaluated by an independent third party. We can help you make your program more defensible. The Security Executive Council conducts program reviews, gap analysis, offers enterprise security risk alignment services, and can help create a business case for developing or redeveloping your program. Look for the links to these services in the description of this video.